We're ready when you are.
Okay. Good morning. We will begin our special call meeting of the Hinds County Board of Supervisors. And let me just offer invocation this morning. Oh Lord, my strength, my Redeemer, we come to you thanking you for allowing us to participate again this morning. We thank you for each and every one here. We pray that you will bless us as we move forward in this meeting. Go with us, stand by us. Lord, bless those that were troubled in the hurricane throughout the United States. Bless them and keep them in your care. Give us strength and courage to continue on. In your name we pray. Amen. Okay. We will move forward with our special meeting. And I believe the first we have is Esther Clerk.
Good morning, Mr. President, members of the board. On Friday, the Chantry Clerk's Office sent a package to you with today's claims. Your claim numbers are 5,748 through 5,753. The first claim of interest, which is over $100,000 this morning, is claim number 5751. It is to Cigna Healthcare in the amount of $485,744.37. That is your health insurance for county employees and retirees.
Lady Board.
So moved.
They move. We have a second. A second. Move for our second discussion. All in favor say aye.
Aye.
Opposed? No. Motion is carried.
Thank you very much. The other claim over $100,000 this morning is claim number 5753, which is your primary election workers. This is a total of all the primary workers, and that claim totals $114,880.
Okay, let's play the board. So it's been moved.
Second.
Proper second. Discussion. All in favor say aye.
Aye.
Opposed? Motion is carried.
Thank you very much. The remaining claims this morning are numbers 5748 to 5753, plus 5751 and 5753. Please present the remaining claims.
Okay. Let's play the board.
So
Been moved. Have a second? Second. Move proper second. Discussion. All in favor say aye.
aye.
Opposed? Motion is carried.
We have the order approving the claims portion for today's meeting, August 29, 2011, for your approval.
That's the play the board.
So second.
We move proper second. Discussion. All in favor say aye.
Aye.
Opposed? Motion is carried.
Thank you very much. We request approval of a resolution of the Hinds County Board of Supervisors in the manner of homestead exemption rejections by the State Department of Revenue for the year 2010.
Let's play the board.
So moved.
Been moved. Have a second? Move proper second. Discussion. All in favor say aye.
Aye.
Opposed? Motion is carried.
Thank you very much.
Okay. Next item, Mr. Luke.
Mr. President, if we can come back to the item to allow Mr. Luke to show up for the meeting.
Other than pushing away from the table, you must share your secret.
Just lay low. The reason I was asked to be put on the agenda this morning, we had something thrown at us pretty quick in the last couple of weeks about our records management system. It's quite a long story. I'm not going to get into it too deep, but to make a long story longer, they've asked us to, charge several years ago. It's free of charge. Was always a catch, I think, in the end, and has not been real successful for them. And the cost and all that they're incurring, they advised us that we would be responsible for paying for T1 lines to their system now. Otherwise, we wouldn't have access to any of our records that are in their system now. My first knee-jerk reaction was to put my records on a disk, get them back to us, and we'll get another system of some kind. Well, their system is a proprietary software, proprietary equipment. If they sent you your records, you couldn't read it. So we went back and looked at it, and I think we've got it worked out now. The reason that I was coming to the board, because it was going to have an impact on our budget, the 2012 budget. But I think we've got it worked out where we can cancel 2 lines, one coming from the Raymond Detention Center and one coming from the radio room. And then at that point we can afford to pay for the line that we're going to be required to pay for to keep access to our system, and it will be a recurring charge. But I think we can maintain it within our budget without crying to the board that we need money. So I think at this point it's pretty much resolved. If something else comes up to it, I'll keep you informed. But right now I think we have a wash of money here.
Very good.
Mr. Brown?
Thank you very much, Mr. President. Pete, is this the same technology that was brought up by this colonel from Southern Mississippi, from the University of Southern Mississippi, and that they brought it to the police department and to the sheriff's department? What was the name of it?
It's Magnolia Data Sharing.
But it was a proprietary piece of software that nobody else had. That's
correct. And it's really, the whole system has turned out to be burdensome. It's not user-friendly. It's not police-friendly.
Right. And it doesn't really affect the use or the usage of NCIC at all, does it?
No, it doesn't.
Okay.
So,
but you have to have it in order to maintain the records that were actually transported from your system back over to the other system?
Right.
Okay.
I think from 97 on, we got the proprietary I think 97 forward. But at some point, and Sheriff-elect Lewis will be able to probably make some decisions on that in the upcoming year, whether he wants to do something different in the court system. If my recommendation means anything to you, I can assure you I'll be encouraging to find another system, but finding a way to pay for it is going to be something else because the system is very expensive. Upwards of $500 million for a records management system.
So right now, the thing you're doing is moving the T1 line so where you can pay for the T1 line in order to maintain this until sometime in the early near future.
Yes, sir. That's correct.
Okay.
But anyway, one of the things we hope to be able to do also, and the administrator IT office is working on that, is to work with the company now that we're working with inline, and hope to cut expenses, give us more capabilities, but in the same token, do some of the things that we're not able to do. I guess you want to call it in-house. She's working on that, and hopefully it may be, I'm not sure, it may be coming before the board pretty short.
Very good. Any upgrade to our existing record system would be appreciated. I'm sure
Mr. Page.
First, Pete, let me thank you for finding a way within your budget to pay for this. It raises a question. A few years back, we were looking into T1 lines and whether or not they were, does the county have enough, or do we have too many? And I know we got rid of one in the Emergency Operations Center, I believe. It seemed like that figure was $2,500 a month, or maybe it was, I'm not sure exactly, it was a large figure. I think it's something else that we need to look into, is our T1 line usage. How many do we have, how many do we need, and how can we use them better? Because it is an expensive line to come through, and if there's some way that we can negate a few of these lines. All of it helps in the budget area, and if they're not being used on a regular basis, this particular line, I think Mr. Brad may remember a little bit more about this. We were looking into it the first year. I think it was plugged into nowhere, as I recall, and it was not even being used, and no one was aware of it. And I don't, if I go back to what we call the Marine Corps blinding glimpse of the obvious, it's hard to find a line if you're not aware that it exists. But I'm sure that we have some out there somewhere that over the years have been accumulated for one reason or the other. So I don't know what the process is to do that, if it's an AT&T study or if it's something within the county.
That was a study done on those lines. Of course, that had been some years ago. We probably need to do it again.
I think so. I think it's probably something we can look at and see if we can do away with some of those lines. Because they are expensive lines that come in, and if we can pick up 4 or 5 lines somewhere to go over the size of the county, I think that's all we're doing. And also, I would hardly recognize you when you walked up with your sudden loss of weight. So you look good there.
But thanks, sir. Just worried me at all. Thanks very much.
Okay, thank you.
Okay. Next on the agenda is
approval for salary adjustment for the Public Works Superintendent effective September 1st, 2011.
okay. Let's play the board.
So moved.
We have a second.
I'll second it, but would you make sure that we state for the record the reason why this being done?
The particular employee made a request for his salary to be reviewed. I met with personnel, the board attorney, and it was determined that there was a reason to bring his salary up further for an increase.
Because of the discrepancy?
The discrepancy in the division at the end and related to the other superintendents.
Okay.
Okay, move for second discussion.
Is this budgeted?
We have it within our budget.
Well, I know that. But
We don't,
I mean, it isn't budgeted. Because if you have it within your budget, what you're saying is you're going to take it from something else to make up this difference.
well, specifically, it won't come from anything else. It'll come from our reserves. This is something that was unexpected, so we can't say that it was budgeted.
Okay. Any other questions or comments? All in favor, say aye. Opposed?
No.
Ms. Garrett. Okay. Ms. Williams?
Well, Mr. President, board members, I'm here to request approval of the interlocal agreement between the City of Jackson and Hinds County, Mississippi for the 2011 Burn Justice Assistance Grant Program. The county will get $136,980 to be split between the Sheriff's Department, Public Defender, and the liaison.
Okay. Let's play the board.
So moved.
Second. Second. Discussion. All in favor, say aye.
Aye.
Opposed? Motion is carried.
I also get a request approval to advertise and hold a public hearing for the Home Partnership Act program grant funds that we're applying for rehabilitation.
Play the board.
Second.
Move. Second. Discussion.
I have a question.
Yes, sir.
Mr. Williams, I got an email, or received an email. Is there a procedure that those supervisors that where their districts are inside the city, is there a procedure or a policy that we need to go through in requesting some of this through the City of Jackson, or how do we do that?
No, actually, I spoke to Frank Reed last week at a housing conference, and he did say that it's permissible that even though they're inside the City of Jackson, them be able to approve rehabilitation, one for each sewer soil district.
So in other words, we still go through the process of the county?
Yes.
Okay.
So all we have to do now is just decide
Which
property,
properties?
inside or outside the city.
No, we can do those inside.
That's what I said, inside or outside.
Yes, sir.
Yeah. Okay.
So will you explain the criteria that is used for each individual house?
Essentially, there are 5 grading factors pointing to how bad a shape the house is in. A house has to meet 3 of those to be considered. If it's 3 or 4, then what they will do is do substantial rehabilitation. If it's 5, the house will be completely demolished down to the slab and then rebuilt. And it's based on income and family size. They have criteria like they have to. The deed has to be in their name and those sorts of things.
I guess it's similar to the one that we may not be aware of. We had a similar project.
Yes, sir.
Like that before.
It's the same.
And the same criteria.
Yes, sir.
Okay.
How much money is in that?
It's really based on, there's a maximum amount based on bedroom size. And it's
the total
anywhere,
grant. The total grant.
The total grant that the state of Mississippi has is in, I think, $6 or $7 million.
Okay. Did you have?
Is there any obligation to the municipality after the home is built in X number of years? The reason I ask this is we ran into something in the city like many years ago called the Barney Frank Amendment, and it got into if housing is if a government tears housing down because it's not like it should be, in X number of years they have to rebuild it back if no one else comes in and builds it back. It becomes a municipality responsibility.
Oh, that's the.
And I don't want to trap any of us into that.
That's the one-for-one replacement, but under this program, essentially, we would be building back on the same foundation.
So that's already being, in essence, that's being done.
Yes, sir.
Immediately. Okay.
That was one program we participated in over here, where if you completely demolish a house, and let's say there were only 3 occupants, that was the wife, the husband, and 1 child, you could only rebuild back a 2-bedroom house, and that was one of the reasons I was asking, what is the criteria that is being used to rebuild the home? And because of that fact, even though a house was in bad need of repair or rehab, some families would not participate because they wanted to rebuild naturally a 3-bedroom house. So,
well, under this, you'll bid back on the existing footprint.
very good.
Any other discussions? All in favor say aye. Aye. Opposed? Motion is carried. Okay. This attorney?
Sir, he wants that advertised in the Clarion Ledger.
It's a requirement by MDA.
Okay. Is that y'all accept that as part of your motion? Okay.
Thank you.
Thank you.
Good morning, Mr. President, other board members. I have for your consideration today request for homestead exemptions. As you see, there are requests for homestead exemptions for under number 1, property and testamentary trust established by Howard C. Ross Jr. for the benefit of Mary Jean Hyde, parcel number 507-615, and for the property vested in the Lenny Campbell Holman Bypass Trust, parcel number 551-148 for Bernard A. Holman Sr. The reason why I'm discussing these 2 issues together is they involve a similar issue. These are trusts where there has been designated a beneficiary, and the trust is actually purchasing a home for the benefit of the beneficiary. In these instances, the beneficiaries have filed for homestead exemptions. They have applied for the homestead exemptions timely with the Chancery Clerk's Office, and the Chancery Clerk's Office has presented a question as to whether the homestead exemptions are applicable or not. Looking at the plain language of the statutes, there at least lies a question in that the name of the property is titled to the trust, but the beneficiary is the one requesting the exemption. And after, initial discussions with these individuals, the exemption was recommended for denial. The issue was presented to the Board Attorney's Office. The Board Attorney's Office sought advice from the Department of Revenue, i.e. the State Tax Commission, as to how they treat these situations. And their advice, and it was verbal advice, was their recommendation would be to provide the homestead exemptions. And at this time, I am asking or requesting on behalf of these parties that the board approve the homestead exemption applications pending final confirmation in writing from the Department of Revenue.
Let me ask, you're going to give homestead exemption to the trust?
It would actually be, either the beneficiary or the trust. In some instances, yes, sir, the title of the property is in the name of the trust, and the beneficiary is being assessed a tax. In other instances, it's the opposite. And what the Department of Revenue has stated, that if there is clear intention within the trust for that beneficiary to have use of the property as a main head of household and actually living in the property, then they actually apply the homestead exemption.
Questions, comments?
So the recommendation is to allow homestead exemption.
Pending a confirmation in writing from the Department of Revenue, because admittedly the plain language of the statute is in question. And I think the Chancery Clerk's Office rightly questioned the exemptions. But because we want to be fair to all taxpayers and we want to treat everyone equitably and justly, and we want to do so as, of course, the state recommends we do, is the only reason that we sought advice from the Department of Revenue.
Isn't that the same? Okay. It's been moved.
Second.
Proper second. I was just saying, these are not the same family, but it just so happened the two of them ended up coming at the same time.
Well, exactly. And I have to commend the Chancery Clerk's Office. They are applying their rules consistently. They're not doing anything different from one person to another. So, yes, these are two things that came up. And they have applied the same rule. And so they do apply to treat everybody the same.
Okay. It's been moved, properly second. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion is carried. Okay.
The next matter I have for the board's consideration is a petition for reduction of assessment from Milwaukee Tubes. I believe some or all of you are aware of a petition and an amended petition that's been filed by Milwaukee Tubes to adjust the amount of the 2010 personal property assessment. And after long conversations and meetings with the assessor's office, along with Blake Lawrence, head of economic development, we tried to investigate this matter as thoroughly as we can, and we are prepared to at least present our findings. Mr. Chris Pace, attorney at Watkins Ludlam, is here representing Milwaukee Tube, and I'm sure people want to make a statement today.
Please, and I have with me as well Mr. David Creel. David is the Director of U.S. Manufacturing for Milwaukee Tubes as well.
I I will provide just a very short summary and then ask Mr. Pace to come up and provide, I guess, a statement on behalf of Milwaukee 2. And I will then ask the assessor's office to come up and present anything that they have, as well as Mr. Blake Wallace. And Milwaukee 2 is applying for a reduction of assessment of their personal property tax. Their petition was originally filed in July of 2005. They submitted a rendition to the assessor's office in the amount of approximately $56 million worth of the equipment passing through Hinds County. At the time of that rendition, it was believed that there was an exemption in place for Milwaukee 2. But after further review and consideration, it was discovered that exemption had expired. It ended in 2009. And so Milwaukee 2 did not have an exemption in place for 2010. Since then, they have applied for an exemption. That exemption has been presented to this board. This board did approve this exemption, but it will not apply to 2011. And the board is prohibited. I'm sorry. 2010. Okay, I'm sorry. So 2010. And the board is prohibited from applying an exemption retroactively. So even though the property local business performing the same type of business that it currently the exemption was not in place, it had expired, and therefore cannot be applied for this condition. Subsequent to discovering that the exemption was no longer in place, there was an appeal to the tax assessor's office to amend the rendition that was, or the value of the property that was then claimed in Hinds County. And after a couple of amendments to that, I believe the amount in that claim is approximately $2.6 million as far as an assessed value. So it went from approximately $56 or $57 million to $2.6 million. And the explanation provided was that there was a computational or computer error by Milwaukee 2. They had someone new performing the task of providing information to the assessor's office. And that person, in turn, read the computer information incorrectly, which rendered incorrect data applied to the tax assessor's office. The statute that Milwaukee 2 is applying to present this petition is Section 2735-143 of the Mississippi Code. And they give various reasons that are consistent with subsections 1, 4, and 7 of that code. And that code does allow the board to consider corrections to the tax code. And it says August next. So that means August of 2011 for this particular loan. So according to the statute, it's not time barred if the statute applies. There was a similar type appeal to this board. Some of you are members, Supervisors Calvin Smith, when AmSouth was First American and then AmSouth Bank came to this board under a similar statute in 1999 and 2000. The argument made then was this statute does not apply to mistakes by taxpayers, but it more correctly applies to mistakes by the assessor's office, and it provides an opportunity for the assessor's office to come back and correct any errors. The board in that instance accepted the recommendation of the tax assessor, Mike Barnes, to keep the assessment as it was, and there was a lawsuit filed, an appeal of the board's decision in the circuit court. The circuit court in that particular case ruled consistently with the board and dismissed AmSouth's appeal. So there is at least precedent that this argument that 2735-143 should not apply. You do have some basis for believing that it is substantiated. We all know that we just went through tax protests for this current tax year. I think that was our last year. And I just want the board to be aware that the taxes that Milwaukee 2 is requesting for reduction should not have been done during this current tax protest that have just expired. Everybody who had an issue was to come forward and post in the newspaper. The Milwaukee 2's protest is for last year, for July 2010, and August of 2010, not 2011. So this is not an issue that is only a couple of months late. It's one that's over a year. And so with that, I will ask Mr. Pace to come forward and provide any information he would like the board to consider on behalf of Milwaukee 2.
I'm trying to
Yes, sir.
Thank you.
Thank you. Good morning, Mr. President, members of the board. Thank you for allowing us to appear before the board today. I'd like to thank Ms. Martin as well for her presentation. She and the folks in the tax representative's office have been very helpful in the last few months in trying to help and work with Milwaukee Tools to resolve this problem in 2010. Just to give you a little bit of background, just so you know who we're talking about. So Milwaukee Tools has their manufacturing facility located in the city of Jackson. They're out of the industrial park by Hawkins Field. They employ about 67 full-time employees and have another 23 they have on a temporary basis that are working full-time. Those jobs on a full-time basis pay about $19 an hour. Milwaukee Tools has been in Jackson for almost 40 years. They built that facility in 1974 and have grown it over time and have maintained the base of operations at Jackson. I have with me Mr. David Creel today. David, as I introduced earlier, is the Director of U.S. Manufacturing for Milwaukee Tools. David lives in Hinds County and oversees Milwaukee's U.S. manufacturing operations. And I'll try to keep this as brief as possible. To Ms. Martin's point, we are a year sort of after the original assessment for this property, coming to the board and asking for the board's assistance in correcting what admittedly was a clerical error on behalf of Milwaukee Tools. Milwaukee has 3 different locations in Mississippi. They have a manufacturing facility here in Jackson, they have a manufacturing facility in Greenwood, and they have a large warehouse and distribution facility in Olive Branch in Soda County, Mississippi. And without getting into, I guess, the statutory permissibility of what we're asking for today, I guess factually what we're seeking approval from the board for is to help Milwaukee correct what has turned into a $1.4 million tax assessment on inventory that was not ever located in Milwaukee's Jackson facility. They over-reported their inventory in 2010. I would like to say it was a computer glitch or some other problem. It was human error. The way Milwaukee does this process, they run a report into their inventory system that generates inventory by line item, by item number, by quantity, by value of that inventory. That then gets put into a different spreadsheet, consolidated by inventory type for each of the facilities in Mississippi. The young lady, the young tax analyst at Milwaukee's parent company, TTI, put together her summary in 2010. She prepared a report to submit to the assessor's office. And when she totaled up, went to the Jackson number, and if you're familiar with Microsoft Excel or any other spreadsheet program, you can do a formula that says equals, and you go to a different worksheet that has that detail, and you say this number, this number, this number, with the purpose of equaling all the various inventory pieces that were stored in Jackson on January 1, 2010. She didn't do that. She picked up one number from Jackson, and she picked up 2 or 3 numbers from the Olive Branch facility, which, as I mentioned, is a large warehouse and distribution facility. And on January 1 of 2010, they had more than $55 million of inventory in Olive Branch. So when she ran the report, created her worksheet, and then flowed into the inventory report filed with Hinds County, she in fact reported inventory stored in Olive Branch, Mississippi. Likewise, they reported some of the Jackson inventory in Olive Branch, and we're currently working with the Soda County Tax Assessor's Office to remedy that situation, they're going to owe additional tax dollars as a result of that. Ms. Martin brought up the exemption issue last year. I think part of the reason why we are here a year later is related to that exemption. I think it's important to have a little background on it. Milwaukee didn't realize this error, there was anything really in this. They've been there for pushing 40 years and pay their taxes every year. They got a tax bill this past December of 2010, for a little more than $1.4 million, which means the same as far in excess of any tax bill they have in the past. They began communications with the tax assessor's office at that point, and I think subsequently with Ms. Martin's office. And based on the correspondence I read, I was not involved in the process at that time. It appears that sort of the popular consensus was that the reason the tax bill was so high is their Freeport warehouse exemption, which had been in effect up until 2010, had not been applied last year. And the reason it had not been applied is because the inventory report had not been submitted by the March 31st, 2010 deadline. And from what I can tell, there was correspondence sort of back and forth with that. Vince Barham and Mr. Wallace's office had been involved and was trying to help resolve the issue and understand what happened. Milwaukee eventually found their postmark date. They sent it certified mail and submitted evidence to the tax assessor's office. The report had been, this is their Freeport inventory report, had been submitted by March 31st deadline. So the exemption should have applied. So they thought. We got involved shortly after that period. My firm did, and I got involved, and began sort of researching the issue. And with Benji Barham's help, asked for copies of the full Freeport exemption, and realized that there had actually been no exemption last year. The whole issue about filing reports on time versus not, whether or not the exemption should have applied, a moot point. Milwaukee should have paid in 2010 all county, city, and school taxes for which they owed, based on the property that they had at their Jackson facility. My first advice to them was if your exemption is expired, the first thing you should do is apply to the county and the city for a renewal. We don't want whatever happened last year to happen again. We did. I want to thank this board for approving that application when it came before. It was sometime shortly after that, we began discussions with Ms. Martin's office, trying to understand what had happened last year. And when I was filling out the application for the new year, we were looking at their inventory numbers for 2011. Their inventory that was in place on January 1 of this year. Their inventory January 1 of this year was about $3.4 million, $3.5 million. We went back and looked at it historically, and historically those numbers are in line with that as well. We got Mr. Creel involved to confirm that that seemed very reasonable to him based on his past experience. His office in Mississippi used to be responsible for submitting these reports before it moved to the corporate function of TTI. And they, with more help than that, he confirmed that they can't physically store $57 million worth of inventory at their facility. It's just not big enough, not unless they got to do the diamond brokerage business. Just, I guess, for a little background, I'm sure the board is familiar with Freeport exemptions. The purpose of the Freeport exemption is to exempt from ad valorem tax goods that are technically in transit in Mississippi. Meaning they've been shipped into the state, some processing done to them for final shipment outside the state of Mississippi. So much, I guess, has been discussed over the past several months between Milwaukee and the tax assessor's office about whether the Freeport reports were filed on time versus not. I guess the point I want to make today, none of that really matters at this point. They were eligible for an exemption in 2010 anyway. So what was on the report versus not is really moot. They technically shouldn't have even filed a report in 2010. They would have filed their personal property condition. Because of these recent, I guess, our investigation when we applied for their renewal this year, realizing that their inventory in 2011 was so much less than last year, and with Mr. Creel's input, we had Milwaukee and the folks at their parent company, TTI, investigate why there was such a big discrepancy last year. We got lots of reports. Finally, got the tax analyst who prepared this to find her work papers, and we submitted those with a copy of the petition, and it was a simple formula spreadsheet. She pulled the wrong number in when she calculated the Jackson number for inventory. As a result of that, over-reporting, albeit an error, Milwaukee was assessed for about $1.4 million on property that was, in fact, an Olive Branch, not in Jackson. We filed a application under 27, 35, and 43, asking for relief and an amendment to the 2010 tax rolls of Hinds County to reflect the fact that, one, this property that was taxed was not actually located in Hinds County on January 1, 2010. And two, it is subject to tax in another jurisdiction, Mississippi, DeSoto County. I have admittedly not read the specific case that Ms. Martin brought up, but have had similar appeals in other jurisdictions around the state. And I know typically it is not abnormal for counties to use that section to make corrections for any reason. Certainly, the decision by the board today is at your discretion. Can't deny that. That's the plain language of 143. It says the board may. But there's nothing in the statute that prohibits the board from granting relief to Milwaukee Schools for 2010. Look at the statute as well. It simply says that the board may correct a prior year tax roll if it makes one of the following findings. We're asking relief today primarily based on two of those. Number one, that the property, based on the evidence we've provided to Ms. Martin's office, the tax assessor's office, the inventory count in 2010 was only $2.6 million, not the erroneous $57.6 million that was reported in error last year. So property that was not actually here was subject to tax. And two, that property is actually subject to tax in another jurisdiction, the state of Mississippi, DeSoto County. Hopefully, we provided an adequate amount of information to the tax assessor's office. We provided them not only those sort of work papers from Milwaukee's tax analyst, but also, I don't know how big the spreadsheet was. You got kicked back on email twice. A very large spreadsheet that went through all of Mississippi's inventory in 2010 for each of their facilities here, broken out by every item number they have. They've got a lot of moving parts. Let me tell you, it was broken out by item number, the number that they had stored on January 1 of last year in each of their facilities here, and the value that it had. So if you tie back those summary reports and the correct numbers that we have since submitted to the county, those tie back to that very lengthy, itemized, line-by-line list of inventory for 2010.
Mr. Brown.
Thank you very much, Mr. President. I have one of the things that was kind of drilled into our head at the police department was a mechanism that we use for solving a problem or correcting a problem. And you probably already answered this, but could you tell me basically what did you know, when did you know, and what did you do about it once you found out about it?
But we knew there was a problem starting in December last year.
And that was
the day the tax bill came out. I'm using the royal way. Milwaukee Tools knew there was a problem. And they contacted the tax assessor sometime in January, that shortly after receiving that bill, to try to understand what happened, why the tax bill had gone up from a few $1,000s to well in excess of $1 million. As best I can tell from the correspondence that I reviewed and talking to the folks at the corporate office, 3-4 months elapsed while everyone was trying to figure out why the exemption wasn't applied. The Freeport warehouse exemption that had been granted back in 2004. There was some discussion about the fact that the reason it had not been applied was because Milwaukee had not submitted its Freeport inventory report in 2010 on time. They had mailed it on March 31st, which is the deadline for submission. It was not received by the tax assessor's office until August 2nd. So I guess use perhaps a bad analogy. They were chasing the rabbit down the wrong hole. We got involved specifically initially to help them file a new application to at least avoid this problem going forward. And we're asking them questions like, okay, as part of the county has a form that you fill out when you apply for a new Freeport license, and it asks you how much inventory you had current year. And looking at that, it was far, far less than $57 million. And I think part of the problem here is you have folks like Mr. Creel and the other folks at Milwaukee, Mississippi that are very, very familiar with what's on the ground here, what's possible. As David told me, there's no way we can store that much inventory in our facility. The folks in the corporate tax department are managing not only Milwaukee, they have other brands, Royalty, Home Life, what have you. There's no, I guess, first-hand knowledge there whether a particular number is right or wrong. It's just the number that gets reported to them. And in this case, the correct number you get reported to them, this young lady just made a critical error on a spreadsheet when she was doing her summary. We realized that, I guess, by the time we got anywhere close to an accurate number, all they had was inventory movement numbers for 2010. This was all the inventory that circulated through Jackson all of last year. That number was about $4.6 million, which we reported to the county. And we had to go to their corporate office, the Milwaukee corporate office in Wisconsin, and have their finance department run this large spreadsheet with 50,000 cells that listed every idle inventory in 2010. We got that sometime in late July, early August, and started trying to go through that and summarize it. And I received from Milwaukee their analyst actual work papers a couple weeks ago. As soon as we had that information, we've already been working with Ms. Martin, letting her know and letting the tax assessor's office know that something was amiss. We had a big number in 2010 that doesn't look like our other years.
You don't commingle your inventory with the other two locations here in Mississippi, is that right?
No, sir. They can do their reporting. What we finally got from them is their reporting by location. But yeah, the one thing I want to stress is Circuit Court, Hinds County Precedent notwithstanding, there's nothing in the statute that prohibits the board from making a finding and amending the tax rolls for 2010.
Yeah.
I have a question for the tax assessor. Is it possible that...
And actually, I was going to request that they come up and more specifically answer the question that Supervisor Graham had, what they do when they do it.
More important, what they do about it.
Well, I don't know. The tax assessor can answer what they did about it. But I believe the tax assessor's office has better information than I would have as to what was done.
Well, thank y'all each very much this morning. We appreciate the opportunity to appear before the board. And if I can come back up or answer any other questions, I'll do that.
Okay. You may have.
Let me just ask this question. Is it possible, Mr. Stokes, that for their 2011 tax return, that returns that they can apply the overpayment as a tax credit?
Yes, ma'am, I did. If I may interject one thing, I failed to mention in my presentation, and I apologize, because this was such a large amount and the company believed that it, at the time, February 1, it should have been exempt, the company elected not to pay that tax until this issue had been resolved. So no amount has actually been remitted to the county.
And I would like to, put one of the things that I had to put in perspective when I learned that is, from what I understand, those figures are ones that are utilized by the tax assessor's office in coming up with the expected revenue for the county. And so that amount of tax is actually anticipated by the county as revenue and utilized to formulate the budget. And we're seeing here today that it was not paid. So that's a $1.4 million gap, I guess, that the county did not get, that it anticipated getting in last year's budget.
I was somewhere in the back of my mind, I was of the opinion that the law states that even though there may be an error that you pay it and then, but I don't see no reason to rationale for that, but and then be reimbursed the way when you find an error. Am I correct in that?
Yes, sir, you're correct. The one avenue the law provides for an error in assessment of taxes is for the taxpayer to pay it, and then at request for refund, so to speak, when the correct assessment is made. And that's exactly how we advise taxpayers when they come to the county with regard to an overassessment in taxes.
Let's clarify the question that, or the comment, the statement that has been made. If there's an error, then the taxpayer can come back and request a refund. But is that error a part of the taxpayer's fault, or is that error a part of the tax assessor's fault? So we need to differentiate between whose error is it, whose fault is it.
I believe the law allows an amendment or a reduction or further assessment, regardless of who the error is from, whether it's the tax assessor or the taxpayer. But more likely than not, yes, ma'am, it is the tax assessor. For instance, when I come to before the board and there's been an error in assessment, it's been when there has been, for instance, a building that burned down on a particular parcel, and it should not have been an assessment for that building. So it's not technically something that's done by the assessment office, but it's through no fault of the taxpayer. Those are the ones we typically, that I typically present before the board. Yes, ma'am.
Good morning. Good morning, Mr. President, Supervisor. To answer your question, going back to Supervisor Graham, when we got the word that after the tax bill was mailed out, Milwaukee 2's only issue at that time was the Freeport exemption. There was an argument about the date and the time it was received in our office, and when it was stamped dated. At that time, we told the tax grants that it would be denied because it made it in our office, in our hands, too late. That's the only response that we had at that time in 2010 from Milwaukee 2. So at that time, Benji used to work with Blake, got involved. Had Benji involved and also Attorney Martin. And the whole issue was about the Freeport exemption. Nothing ever came up about numbers, or nothing ever came up about one of their employees made a mistake. It never rose to a week ago, maybe. I got it from Ms. Martin.
July. I believe it was July.
July, okay. And that's when
July 2000.
Okay, and that's when my office got involved to look at the situation and some things that's going on. Now it's true, 2731-143 gives the assessor as well as the board of supervisors the authority to change an assessment. But my role in this, if the tax assessor's office, and supervisors, you know this, if we made a mistake, what we would do is come in under that statute and tell you what the reason was and present it to the board. This was not, in my opinion, a mistake from the assessor's office. Even though people make mistakes, it might be an error that's pointed out from Milwaukee 2, but we were never even aware of the mistake. And I would like for my chief deputy, Laura Burst, to come up with a little more depth